And when you're young and you're in your 20s, you're trying, at least I was, you're trying on personalities like they're shirts. You're literally just, I'll be this person, I'll be that person. And one day you've stolen from 1,000, so you're a genius, not a thief. And instead of stealing from one, and you've pulled all these different references in and these feelings, and you know yourself. And I thought, whoa, that's weird, because both are stories that aren't true. They're not what I know to be my story.
Hi besties, it's Katie from Without a Crystal Ball. Judge Lyman, or as some of you call him, Judge Lehman, might finally be taking the Van Zaan situation seriously. Or maybe not. Honestly, it's hard to tell. His rulings on motions to compel have been all over the place. Sometimes he grants them, only to later dismiss the entire issue, so I'm cautiously optimistic here. But in this instance, there's at least one sign that he's paying attention. He's allowing Jen Ale to move forward with her theory about what Stephanie Jones, Works, Blake Lively, Ryan Reynolds, and Ryan's company Van Zaan Inc. allegedly did back in September 2024. Specifically, their alleged scheme to obtain the contents of Jen Ale's phone. Now, here's where it gets messy. Van Zaan Inc., Ryan's company, responded to the subpoena by insisting they shouldn't have to hand over anything. No records, no communications between Van Zaan, Blake Lively, or Works. Their argument? That responsibility supposedly belongs to Stephanie Jones. But Judge Lyman didn't buy that story, and over on the other case connected to this one, things are getting even more complicated. In the latest twist of Lively versus Wayfair, things took a sharp turn last week when Blake Lively unexpectedly referred to Stephanie Jones as a co-conspirator in what she now calls a smear campaign against her. This marks a major shift. For months, Lively avoided linking Jones to the controversy. But now, after Van Zaan's involvement was publicly exposed, she's officially naming Jones as a non-party co-conspirator. It's the kind of move that raises eyebrows. It almost feels like someone cutting a deal, the kind where you agree to testify or hand over evidence in exchange for not being sued. That could explain why Stephanie hasn't faced legal action from Lively so far. Still, the timing is striking. Turning on Jones now fits exactly what a source told me weeks ago, that this alliance wouldn't last once things started unraveling. Ironically, this is the same claim that Jones's lawyer once called defamatory, even sending a cease and desist over it. But sources close to the case had said from the start that mutual betrayal was inevitable. And now, it appears that prediction was dead on. Meanwhile, Judge Lyman's latest order digs even deeper. He's granted Abel's motion to compel production of the subpoenaed documents from Jones, including her communications with Van Zaan and their legal teams. These exchanges could reveal how their supposed coordination actually worked, shedding light on the lawsuit's true nature. In plain terms, the judge wants to see if this was a real legal dispute or an orchestrated setup. Some documents have already been produced, but others, specifically those tied to the Van Zaan action itself, could expose the structure behind what many insiders now describe as a sham lawsuit. And by the sound of it, we're getting closer to finding out exactly what kind of scheme this really was. Request number 9 in the motion focuses on communications between Van Zaan, its counsel, and Stephanie Jones, along with Works and their legal teams, relating to the Van Zaan lawsuit itself. Van Zaan's position was that these documents weren't relevant, and even if they were, the court should compel Jones or Works to produce them first, rather than burdening Van Zaan. But Judge Lyman disagreed. He granted the motion to compel, citing Federal Rule of Civil Procedure 26, which allows discovery of any non-privileged material relevant to a party's claim or defense, so long as it's proportional to the needs of the case. He referenced several key factors: access to information, the importance of discovery in resolving the issues, and whether the expense of discovery outweighs its likely benefit. Essentially, if one side can show that the requested evidence could meaningfully impact the case, the other side must have a strong reason to withhold. Judge Lyman then summarized Abel's argument that these communications could prove Jones and Lively conspired to obtain Abel's stolen data and use the Sham Van Zaan lawsuit to disguise that theft under a facade of legal legitimacy. The argument goes further, that Jones transferred data allegedly taken from Abel's stolen phone to Lively before any official subpoena was even served, potentially showing premeditated coordination. Van Zaan, in contrast, argued that Abel's claims had nothing to do with them, that the alleged misconduct stemmed solely from Jones's possession of Abel's phone, not from any actions by Van Zaan or its representatives. But with the court now granting the motion, those protected communications are officially in play, and they could determine whether this was truly a standalone lawsuit. or a calculated setup engineered to hide the transfer of stolen information. The court's order goes on to clarify that Jones's employment was terminated weeks before the Van Zandt lawsuit was even filed, but that doesn't shield those communications from scrutiny. Judge Lyman emphasized that relevance under Rule 26 is interpreted broadly, encompassing any material that either directly bears on or could reasonably lead to other evidence that bears on an issue in the case. Under that standard, he concluded that the requested documents are indeed relevant. Abel's claim is that Jones disclosed some of her private communications to the Lively parties as early as August 21, 2024, and that she continued to access Abel's text messages afterward. At some point, Abel alleges, Jones transmitted stolen communications to Sloan, Lively, and Reynolds with the intent to harm her. What makes this ruling particularly striking is how the judge framed it. The statutes under which Abel filed her claims prohibit both obtaining and disclosing protected information. That's significant because when Kristen Teller, representing the Lively side, filed her motion to dismiss, she argued there was no hacking, no illegal access, and no theft, that the phone data in question was Jones's property, not Abel's, but Judge Lyman's language suggests he isn't entirely dismissing Abel's allegations. By citing both obtaining and disclosing as prohibited acts, he's acknowledging that even sharing data unlawfully taken from a protected computer could constitute a violation. This point also connects to Tor's earlier argument, where the defense tried to have the protected computer classification removed altogether, claiming Abel couldn't prove hacking. The judge's phrasing, however, hints that he sees enough potential merit to allow discovery to move forward. Ultimately, he concluded that communications between Van Zandt and its counsel and Jones works are likely to shed light on whether and when Jones accessed and disclosed Abel's private communications, and whether Van Zandt or Lively were complicit in receiving that stolen data. In short, the judge isn't convinced this is a baseless conspiracy. He's signaling that there's enough smoke here to justify looking for the fire. So, at the heart of Abel's case is a very clear accusation. If Stephanie Jones accessed data from Abel's phone and handed that private information to Sloan, Blake Lively, and Ryan Reynolds before any subpoena was issued, that's not just unethical. It's a blatant breach of contract and a serious privacy violation. Abel's position is that she and Jones had a confidentiality agreement, meaning any disclosure of personal or work-related communications was forbidden. Jones, however, has tried to defend herself by framing her actions as part of a speak-out effort, essentially claiming that her right to share her experiences overrides that confidentiality clause. Judge Lyman, however, appears unwilling to dismiss Abel's allegations outright. His reasoning suggests that while he hasn't made a final ruling, he wants Abel to have a fair chance to prove when and how this happened. He's essentially saying if Jones did pass along stolen communications before the subpoena, Abel deserves the opportunity to uncover that timeline through discovery. Van Zandt, Ryan Reynolds' company, pushed back, arguing that Abel's entire case could soon be thrown out because there's already a pending motion to dismiss. Their stance was, if the case might be dismissed, why bother with discovery? But Judge Lyman rejected that, writing that the motion to dismiss is still under consideration, sub judice, and until it's officially granted, Abel remains entitled to pursue discovery. In his ruling, Lyman stated plainly that Abel has demonstrated the relevance of the proposed discovery. In other words, her requests aren't a fishing expedition. They're directly tied to the central question of whether confidential data was wrongfully taken and shared. He also addressed one of Van Zandt's recurring objections, that Abel should have to get the same information from Jones first before asking it from Van Zandt. The judge dismissed that outright, noting that there's no rule requiring a party to exhaust all other sources before subpoenaing a third party. He also pointed out that Van Zandt hadn't shown that turning over the documents would be overly burdensome. So, once again, both Van Zandt and Jones were trying to deflect responsibility. Each insisting the other should provide the evidence. The court wasn't having it. Judge Lyman made it clear, stalling discovery isn't an option. And while this ruling doesn't guarantee that Abel's case will survive the pending motion to dismiss, it's undeniably a win for her. A small but significant acknowledgement that the court sees enough legitimacy in her claims to keep digging. When Lively's team issued subpoenas in the California case, the judge there essentially said, "This isn't my jurisdiction." Rather than ruling on the matter, he decided to transfer the motion to compel to New York. where Judge Lyman is already overseeing the core of the dispute. That means Lyman, who has shown a willingness to dig deeper, will now decide whether those documents must be turned over. In California, Lively's side argued that advocating for a client doesn't automatically give anyone the right to access privileged communications or firm records. It's a classic legal shield, one meant to protect attorney-client confidentiality. But as the court noted, there are exceptions. If someone can demonstrate clear relevance and that the communications may expose potential misconduct, like a coordinated misuse of legal process, the court can order limited disclosure. And that's what's happening here. Abel's side isn't asking to see private emails between Ryan Reynolds and his lawyers. Instead, they're seeking communications between the attorneys and the other parties, such as Van Zan, Jones, or Jones Works. About the Van Zan lawsuit itself, Judge Lyman has already indicated that these exchanges could be critical. If they show that this so-called lawsuit was structured to launder stolen evidence, meaning to disguise or legitimize the transfer of illegally obtained data, it would directly support Abel's claims. It's a pivotal moment. The fact that the California judge deferred to New York rather than blocking the request altogether suggests that even other jurisdictions recognize the seriousness of the allegations. For Jen Abel, it's a hopeful development, one that could finally bring transparency to what she's alleged from the beginning, that the Van Zan lawsuit wasn't real litigation at all, but a front. As for Ryan Reynolds and Blake Lively, this ruling could put them in a tough position. Despite their team's insistence that they don't owe anyone discovery, Judge Lyman has made clear that this court expects cooperation. And given how aggressively Ryan has demanded transparency from others, it's a bit ironic, because now he and Blake may be forced to hand over their own communications for the first time. The latest development focuses on records detailing the communications between the attorneys involved in the Van Zan lawsuit, specifically how the subpoena process unfolded and who coordinated it. The reasoning is simple. There's growing suspicion that Van Zan's lightning-fast subpoena filings within just 4 days of the suit couldn't have happened without inside coordination. Judge Lyman seems to agree that it's fair to question how Van Zan knew exactly what to subpoena and why. Those details, who gave the direction, what the purpose was, and whether Stephanie Jones ever objected, could expose whether this was legitimate discovery or a pre-planned data grab. Because if Jones never pushed back and simply handed over materials tied to Abel's phone, that would look damning. It would suggest that the lawsuit was being used to launder stolen communications under a veneer of legality, which goes to the heart of Abel's entire claim. At the same time, in the interest of fairness, Judge Lyman also addressed a related issue involving Jed Wallace, whose case is also under a pending motion to dismiss. Lively's team had requested access to Wallace's client list, and Wallace sought a protective order to keep those names confidential. But the judge denied that request, applying the same broad discovery principles he used in Abel's favor. Lyman once again cited Rule 26, emphasizing that discovery in federal cases is intentionally broad, allowing parties to explore any line of inquiry that could reasonably lead to relevant information. Even if the connection isn't direct, if it could potentially help prove or disprove an issue in the case, it's fair game. He also noted that Jed Wallace isn't a licensed doctor or therapist, meaning he can't claim doctor-patient or therapist-client privilege. And while he may have confidentiality agreements with his clients, those don't override a valid subpoena in court. In other words, if he made promises of secrecy in matters involving sensitive or health-related issues, those promises can't shield him here, because there's no legal privilege for that kind of confidentiality. So, once again, the court is signaling consistency. Discovery will move forward broadly and transparently. No special protections, no delays, and no excuses, and perhaps most importantly, Lyman's repeated reference to the speed and coordination of the Van Zan subpoenas suggests he's taking seriously the question that underpins everything. Was the Van Zan lawsuit a legitimate case, or a calculated operation to collect and disguise stolen evidence? The central issue here is that Lively's team wants to see whether Jed Wallace's firm, Street Relations, has engaged in similar digital reputation campaigns for other clients, like the one she's alleging was used against her. The idea is that if Street Relations has a pattern of orchestrating smear operations or manipulating online narratives, that behavior might show a business custom or habit, strengthening Lively's argument. Now, personally, I'm not convinced by that logic. Whether a PR firm did work for other clients doesn't necessarily prove they did the same thing here. Context matters, and so does intent. Still, Judge Lyman ruled that evidence from other client campaigns may be relevant if it reveals consistent practices or techniques used to damage reputations online. Street Relations argued they'd already agreed to testify about their services for anonymous clients, but the judge sided with Lively, saying she's entitled to test that claim herself to analyze the digital fingerprints and see whether those campaigns mirror the tactics allegedly used here. And despite Street Relations' concerns about confidentiality, the court wasn't persuaded. Lyman wrote that sensitivity and confidentiality don't equal immunity. Courts handle confidential documents all the time, and those protections exist through protective orders, not instead of them. Since a protective order is already in place, any private material can be marked confidential, redacted from transcripts, or even discussed in closed court if necessary. So, bottom line, Jed Wallace has to turn over his client list. Now, this is where things get interesting. Wallace's involvement was incredibly brief. He joined the Lively team on June 9th, and just 3 days later, they were already accusing him of running a coordinated smear campaign. Frankly, that doesn't add up. It's nearly impossible to pull off a large-scale digital operation in under 72 hours, especially when Lively was already facing major backlash long before Wallace ever got involved. Whether you support Lively or not, this raises bigger ethical questions about the PR industry as a whole. Just because these agencies can